Welcome back. In this video we're going to have a look at the issues related to contracting with miners, specifically for the purposes of the assignment. So this is the assignment instructions for this part, and you're required to set out applicable law, which means the principles relating to miners contracts, and a set of facts which you are going to draw from your business plan where you would contract with a miner, possibly as a customer and potentially as a supplier. You may have to make up additional facts to allow you to do this. So discussing the implications for your business for entering a contract, in other words, how would you ensure the contract is enforceable or that you can in fact sue somebody under the contract. Provide a set of facts to illustrate a situation where you're contracting with a miner which will not be enforceable, and this will flow from following through the legislation deciding when the contract would be unreasonable. And provide a set of facts where the court may provide compensation or restitution. Now, this assignment is really simply about following through the steps related to miners' contracts. So down here, these are the notes which are on Canvas related to capacity. So just to summarize here, capacity, the ability to enter a contract to bind yourself. And most people have this, but there are some exceptions where the person may not have capacity, which includes miners, companies, people with limited mental capacity and bankruptcy, and we look at two of those in this course. Now the first step here is to decide who is a miner, and this is under the Miners Contracts Act, so it's a person under 18 years of age, and we'll see that when we turn to the Act itself. The process is really quite simple. It's just a series of steps. The person's under 18, we go to section 6 for their contracts, and we have a prima facie. Prima facie means a starting position. So we start with our prima facie position that is unenforceable, and note it's against the miner, whereas the miner can sue the other party. So it's only protecting the miner, not the other party, unless of course they are also a miner. Now that's only a prima facie position, and we can change that if we can prove that the contract is fair and reasonable, which is what you would have to ensure when contracting with miners in your business, that they are fair and reasonable. How do we know if it's fair and reasonable? We simply look at the criteria in section 6, subsection 3 of the Act. Now, onus of proof is who has to prove this to be fair and reasonable, and that's not the miner. So if you are contracting with a miner in your business, you will have the onus of proof or burden of proof to show that your contract was fair and reasonable to enforce it. It's not for the miner to show it's unreasonable, it's for you to show it is reasonable. And what's the court going to do? It's going to set out the remedies in section 6. For example, it may cancel the contract. In addition to that, we have compensation and restitution, property transfer, so money and giving the property back or transferring property. So section 6, they cancel or modify the contract, but this doesn't do anything to any payments or goods. In section 7, they can transfer goods back and order payments. And those are what we'll call the remedies. Now, you also note that it's possible to avoid the application if you go to court and get prior approval, which you'd only do for major contracts. The reality in most business situations with miners for significant contracts is people seek guarantors, which could be parents or other persons who enter into a contract with the creditor saying that they will pay if the miner doesn't. And since that person would normally not be a miner, then most businesses would simply not go through the process of proving the contract fair and reasonable. They would simply ask the guarantor for the money because they're not a miner, and it doesn't matter in this regard whether it is fair or reasonable against the guarantor. So the first point noted was the question of who's a miner. Now if we go to the interpretation section, you can see a miner means a person who has not attained the age of 18 years. So not attained 18, so from on the person's 18th birthday, they are from that point on a person of full age for the purposes of contracts. Okay, so let's go back to our contents. And the next section we talk about is the contracts of miners. So we're not talking about life insurance or contracts of service. Contracts of service are contracts of employment. So if we're looking at miners, we'd look at this area for the contracts of employment. However, the law of employment contracts would have more application for you in this regard. This would be in addition to it. However, we're not dealing with that in the assignment. We are dealing with contracts of goods and services. So where do we get those basic rules from? It says here, every contract entered into by a minor is unenforceable against the minor, but otherwise have effect as if the minor were of full age. This is why at this point we're saying you can't sue the minor because it's unenforceable, but here the minor can sue you. Now further on, this section is saying the court may inquire into the fairness and reasonableness of the contract. So they look at whether it's fair and reasonable, and the court may, in its discretion, enforce the contract against the minor if they think it's fair and reasonable. They could declare it binding in whole or in part, so bits of it. Do other things to cancel the contract, and then use the remedies in section 7. So from there, we turn to section 7. And if we scroll down through here, we'll note where the court may exercise its powers, section 5 or section 6. It may grant to any party to the contract, any guarantor or indemnifier. Indemnifier is a similar situation to a guarantee, which we discussed in class, and such relief by way of compensation or restitution of property as the court thinks in its discretion just. So they can simply order payments and they can order transfer of property. So let's take a simple example of, this is our minor here, and the minor wishes to buy a car and enter into a contract to do so. So in this case, we'll assume there's going to be a contract entered between the minor and the dealer. So there would need to be some form of contract drawn up. So let's assume, for argument's sake today, that our contract involves a 1996 Toyota for $5,000, which this is my Toyota. Servicing by the dealer for $200 every 3 months, insurance of $1,200 per annum, payments 36 months, so this is hire purchase contract, 18% finance rate, and a $1,000 deposit. Now we're assuming our friend here is under 18 at the time of the contract. We may be in court sometime later. He may in fact be 20 at this stage. However, if he was under 18 at the time of the contract, then the Minors Contracts Act applies. So they go through the process, they draw up the contract, he gets his car, and now he's happily driving down the road. And of course the inevitable happens, and he meets a friend head on. And the final result is we have this scenario. We still have a contract between the two parties. The dealer has the money, and the dealer has a smashed up car. And what is the minor going to do? Now, at this stage, we're going to have to go through the law, and we start with that basic proposition of the dealer cannot sue the minor. So at this stage, the only options for our car dealer to get the remaining payments under the contract, so we'll assume that our friend here has paid the $1,000 deposit, but has yet to pay any further payments. So there's a 36-month contract for $4,000 outstanding at 18% interest. Now all they can really do is go to court, and they're going to have to get in front of the judge, and the dealer is going to have to show that this contract is fair and reasonable. So at this point we need to go back to our legislation. So our first step is to say the contract's with a minor. Our second step is to say that the contract cannot be enforced and it must be taken to court in front of a judge, and the judge has to decide if it's fair and reasonable. Now if we go back to our legislation, that was section 6, and the criteria for deciding if it's fair and reasonable are contained in section 6, subsection 3. So the circumstances surrounding the contract, subject matter and nature and value of the property, age and means of the minor, or anything else. Now there's no specific rules here to apply from the legislation other than saying these are the things the court will look at. So in your business, you would consider such matters in deciding whether to contract with a minor or not. One of your policy positions may be not to contract with minors for any contract above a certain value, for example. That's up to you. So if we go back to this contract, what have we actually got? We've got a contract for $5,000 for a 1996 car, which sounds expensive. The servicing looks fine, it's not unreasonable. $1,200 insurance for a 17-year-old buying a car is probably about right. 36 months, 18% finance rate. It's a high interest rate, but higher purchase is risky, so that makes sense. And the deposit's $1,000. So overall, this contract is probably not fair and reasonable simply because the contract price is too high, but the other matters are acceptable. So what do we think the court's going to do? And again, we're back in section 6, and we can look at these options. So the court may enforce against the minor if it finds it fair and reasonable, but if it finds it's not fair and reasonable, it can cancel the contract and orders as to compensation and restitution as it thinks just. So if this is unreasonable, then the court is likely to cancel this contract, that's its main option, and then order compensation and restitution under section 7. So let's just go back to section 7. This is our compensation and restitution as talked about before. Compensation is money, restitution of property is transferred back. So in this example, it's quite hard to decide what will actually happen. The minor has crashed the car, so the circumstances of the crash will be relevant to whether the minor gets any money here. The dealer should never have sold the minor this vehicle for $5,000, so is unlikely to get any compensation. The possibilities here might be that the court requires the minor to pay an additional sum of money as compensation for the damage caused to the vehicle if the accident was the minor's fault. If the minor was driving recklessly, for example, that's probably quite likely. If, however, the accident was not the minor's fault, then it's hard to imagine anything happening here. That the court might simply say the dealer keeps $1,000 and loses the balance of the vehicle, and the contract is cancelled and the minor walks away from this. Discussion here is what should the dealer have done to avoid these problems? Now, one option is to have gone to the court in advance under section 9 and asked the court, the judge, to pre-approve the contract. And this amounts to going to court proving it fair and reasonable in the first instance prior to contracting, which is often not practical and would have to be for substantial contracts. The other option is to seek a guarantor. Now, if we go back to our first picture here of forming the contract, this is the point of time where you have to get the guarantor. So let's assume we've got this is Sally, and that's our minor's mother, for example. And a contract would be entered into here between these two parties. Now that is a completely separate contract, so we'll move this one up here, and this is a contract of guarantee. Now that exists independent. So provided this person here is not a minor, the Minors Contracts Act does not apply to this contract. It only applies to this contract because this person is a minor. Therefore, when we go through to our final scenario, which is before the judge, and we bring our friend Sally here back into the arrangement, then this is not part of the court hearing. The dealer is simply going to enforce this contract against Sally, the parent, and does not have to go to court. So you simply wouldn't bother with any of this, and you'd enforce the contract against the guarantor under Section 10 of the Minors Contracts Act. So just finishing back with our assignment instructions. What are the implications of entering a contract with a minor? How do you make sure it is enforceable? Going through those criteria in Section 6.3 and deciding if it's fair and reasonable in advance. Consider a fact situation where an employee may enter a contract with a minor which is not fair and reasonable against the minor. Remembering contracts against minors take into their age is taken into account. Therefore, what could be fair and reasonable against an adult may not necessarily be fair and reasonable against the minor. And then think of a situation where you do have a contract with a miner and there is damage. Could you end up with compensation and restitution in that situation? And since we've been talking about miners, we'll finish off today with a picture of a baby elephant.